Так, сейчас пойдет. Ага, пошло, закрывай дверь, хотя бы слышно. Здравствуйте, наши веб-зрители. Сегодня у нас очередной вебинар, и говорим мы о теме, которая крайне актуальна для всех текущих и ожидаемых пользователей английских компаний. Сегодня мы обсуждаем ожидаемые изменения к корпоративному законодательству Великобритании. И нашим гостем является сотрудник GSL, в прошлом сотрудник White & Case, а также английский солиситор Аня Кушебок. Заранее прошу прощения перед нашими русскоязычными слушателями, диалог наш пойдет только по-английски. Но, однако, вы сможете в скорости увидеть расшифрованную стенограмму на русском языке, собственно, здесь же, в записи этого вебинара. Okay, maybe just few words. You will introduce yourself in correct way, not in that way which I introduced you.
Well, whatever you said was correct. I used to work for a few years for White & Case, primarily working with international clients in the Budapest office, and I've been involved in setting up tax-efficient structures, multi-jurisdictional structures for investments and for carrying out cross-border businesses.
I see. But now you are acting as a specialist on UK corporate legislation.
Of course, this work which I've previously done has made me involved in M&A transactions, and which are mostly carried out under the laws of England and Wales. And as I am a UK qualified solicitor as well, this is what my role is currently in GSL, to advise clients under UK law.
But now we're advising clients about the expected changes in the UK Companies Act. It will be
well, it's not 100% known yet which act will be changed, but most probably yes, on the level of company laws of the UK. There are some expected changes.
Okay, so let us talk about the most important for our clients' issues, which I have in mind. Actually, three issues. The first one is the prospective opening of public register of beneficial owners.
Yes, I understand it from market participants and fellow professionals. This is something that has been a topic for a while, not only now, but in the past about 9 to 10 years in the UK, that they should probably gain trust of international organizations and business leaders by creating such public registry for beneficial owners. It is again on the table. In June, the UK government started this program, which, as you said rightly, affects several parts of company legislation, and one of them is this. Whether it is realistically expectable that this legislation will come in force or not, we can of course not predict, but it is one of the main parts of a discussion paper which lays out the expected changes.
I see. And these expected changes may be enforced, as you told on our internal seminar, by the end of working of current parliament.
Yes, the discussion paper is the first which has been issued in July. And
sorry, and what is discussion paper?
Exactly, this is what I wanted to say. The discussion paper is basically the first step of bringing any new laws into effect. It's the first step of lawmaking process in England. The government side prepares a discussion paper with the proposed changes, and it opens a discussion as it's
discussion in Parliament or in public?
In public. Basically, all the sectors, advisors. So they basically want to test the waters, what the law-obeying industry says about the proposed changes, what the effects could be, how much it might cost, whether the pros and the cons make it worth to actually create such laws. And then they evaluate these answers which they received. The discussion period was open until the 16th of September for this particular discussion paper. Then
So it's finished.
It has finished. All reactions have been submitted. Then they evaluate what they received, and on the basis of that, they start drafting the actual text of changes of laws.
I see. Okay. So now coming back to the register of beneficial owners. So I suppose that who are the subjects? Who are those who are obliged to provide the information on the beneficial owners? I suppose it is registered agents, corporate service providers, the law. Okay.
No, actually, the proposal, we want to make companies to be liable. The actual companies who are registered in Companies House Registrar to be liable to hold information on their own beneficial owner.
To hold not only on their papers but also to provide, submit publicly.
The proposal basically gives a few levels of proposed changes. First, that the company should hold this information on their own, like a members register, but for beneficial owners on their own records. And then they elaborate on this, and they say this probably would not deliver the desired result. So they should make this member register, beneficiaries registers public by submitting this information to Companies House. So they, following a long elaboration, the final proposal is to make it public by making the companies themselves liable to submit this information to Companies House.
So the subjects of the law are the companies themselves and not those who render the services.
Exactly. And then how it will then technically be done, for example, with corporate services, corporate providers like GSR UK, then it will probably be with the help of these corporate service providers, but the actual legal people, legal persons who are liable towards this obligation will be the companies themselves.
I see. Okay, let's go further. So another substantial change is related to shadow directors, or our word nominee directors, and what is told about these proposals?
Well, basically the point of the lawmakers is that such a thing as nominee director doesn't exist in the corporate legislation in the UK. All directors, whether they hold one office or they hold 400 offices, they're under the same obligation of fiduciary duty towards the company. Of course, they say, we all know that de facto we have directors who act as nominees and don't actually have wide knowledge of the company's affairs. They say that at least as a minimum, again there are different levels of suggestion, as a minimum those directors who act as nominees should make it known, should make this fact known to the company's register, that they actually assigned their powers, they diverted the powers from themselves to beneficiaries or shareholders or whoever by letting this known to Companies House. Then again they go further and they say, but this is again de facto is a breach of their fiduciary duty, because as soon as they sign such a power of attorney or other legal document giving away their powers, they basically breach their legal obligations towards the company and whatever is put on them by the Companies Act. So for that reason, this should be not permitted, that actually directors who nominally seats.
But up to now, there is the obligation of the company and of the director just to indicate that they act as nominees.
As I said, we're all talking about proposal.
Yes, I understand.
So the proposal is that at least make it known, but furthermore, their suggestion is that ban it somehow, which is, since there is no differentiation in Act so far between nominees and non-nominees, it is interesting to see how they might word it in any legislation, how they might actually exclude the possibility for someone to act as a nominee. Because at the moment, how they try to define a director who might be a nominee is that they assume that any director who holds office in more than 50 companies.
This figure is in the papers?
Is in the paper.
It is mentioned.
It is mentioned that any director who is in the seat of more than 50 companies can be deemed to
I
be
remember
a
that in
director.
Ireland it was proposed 25 directors. Also regarding the indication, long ago, 10 years ago, before Cyprus entered the European Union, and there was the necessity to submit to central bank a special form. In that form, it was the obligation to indicate whether the director works as a nominee or not nominee. So in the past history of this industry, it already happened, but regarding the registrar of beneficial owners, it's never happened, if I'm not mistaken, in the whole
No, I don't
I
think
also
it's
don't know.
As far as I know, I don't know of the jurisdiction.
Okay, yeah. So going further, another way to hide directors was always, not always, but the substantial number of the clients use corporate director. So there is also the proposal regarding the corporate directors.
Yes, exactly. That is along the same lines as we discussed about nominee directors. The UK government believes that corporate directors is indeed, the use of corporate directors is a way to shield the interests and the actual influence of non-desirable business makers. So they believe that they should completely ban the use of corporate directors, even if, as of today already in a UK company, if there is a corporate director, there is a requirement to have a physical person as well on the board. So it's not entirely that a corporate director can on its own be on the board of a UK company, but it is believed by the government that it is non-desirable at all to have such possibility, and perhaps to ban this option.
Just to ban only physical person should be.
Only physical person should
I
be
see,
the
I
director,
see.
which is actually the case in many European jurisdictions.
Yeah, definitely, not only in European. Well, as for me, I consider these three proposed changes as the most dramatic. There are some others, like abolition of bearer shares.
Yes,
Actually, I even didn't know that it was possible in the UK to. In this case, I do not consider it so dramatic. Nobody used it, at least in our industry.
Well, because it did not actually bearer shares. We call them as such because they almost act as bearer shares. They're called share warrants. It is what they would like to abolish. And share warrant is basically a warrant which is given to a shareholder instead of actual shares. This warrant gives right to this shareholder to claim the shares or to buy the shares of the company which have already been issued. But as long as it doesn't do so, the identity of this person is not known. This warrant doesn't bear any name, and the members' registry of the company will only have a note that certain shares are linked to this warrant. So basically, the identity of this person is not known.
I see.
The twist, if I may say that, of this warrant is that actually the person holding this warrant may even exercise voting rights and may even receive dividends while having a warrant instead of the share. But if the person does it, there will be some points in the company's history when his identity becomes known. For example, when voting is taking place.
I see. Okay. Okay. Another thing which I have seen in your papers is something about power of attorney, and you mentioned that it may be offense to use power of attorney.
That is related to the topic about the nominee directors. This is what we talked about. That if a director, which again we emphasize is not a nominee yet because there is no such, if a director signs away, divests its rights and obligations towards the company to a third person, lawmakers believe that it's already per se an offense of the company's law, because he has the statutory obligations which he actually signs away from.
But I suppose this is not the global restriction, because power of attorney is the normal instrument. If it is restricted, if it is reasonable.
Of course not. I think they more believe in this point is being made during that reasoning, which I just pointed out, that they under each topic in this discussion paper, they start from a minimum restriction which they believe is necessary, and then they go to the extreme, so to speak. And this is a point made during this reasoning, that if they only go with that option, that the nominee director should declare that yes, by signing this power of attorney, I've basically given away all my rights and obligations to so and so person, then it is somehow in contrary with the existing laws, because they actually accept an unlawful situation by accepting this declaration.
I see. So, as always, the right balance should be found.
The right balance should be found. So if the director doesn't completely give away all its rights to conduct the business and all basically the knowledge of the everyday business of the company, certainly not in a written declaration, that should not be the breach of
Okay. Well, actually, this is all what I wanted to talk. Maybe you may mark the same dramatic reason of proposals, or maybe regarding the possibility of these papers may become the law, or what you would like to add, which I missed.
If we, only the future can tell what's going to become a law of these proposals. As we started off, the Central Registry of Corporate Beneficial Ownership is the most dramatic of all, I believe, and that is, I think, the most awaited by all to see whether it comes to force or not. I think it would affect the competitive edge of the UK as an investment centre so much that I would personally very much doubt that it will come into force. But that is my personal opinion. I would see the abolition of shares certainly to go, because, as you said, the practical effect is not so great. It's the same with corporate directors, but it sounds good. It's something. If it has something has to go through from this discussions paper, probably these 2 points. I see technical difficulties with pointing and, so to speak, catching nominee directors, but they might just come up, as you said, a number of seats which one can hold without being labelled as such. So there is a little bit of unsure or unclearness there. But the registry of beneficial ownership, we should eagerly wait and see, and hope that it will not.
I see. Okay. Я думаю, что на этом мы прекратим, завершим сегодняшний вебинар, хотя тема, конечно, неисчерпаемая, и ее нужно изучать, держа перед глазами. Лучше, конечно, текст закона, в котором эти предложения еще не вступили. Как минимум, тогда вот эти discussion papers, о которых мы говорили. И это я предлагаю делать очно, предлагаю анализировать, наверное, текущим владельцам английских компаний, чтобы смотреть, хотя бы планировать их свою деятельность хотя бы на год вперед. И также это можно сделать, мы наверняка будем проводить расширенные семинары, а не вебинары, где на эту тему можно будет поговорить с кем-то из наших сотрудников, либо наверняка с Анико. А на текущий момент мы завершаем сегодняшний вебинар. До свидания.
Спасибо.
Так, смотри.